Good morning, Chair and the members. My name is Sarush Safari. I bring both a forensic accounting background and my current studies as a Juris Doctor candidate. That mix allows me to see how systems are structured, how incentives shape outcomes, and how workers can get left behind. My submission looks at liability for psychiatric injury in the Queensland's Workers' Compensation Scheme with finance and accounting roles as the focus, though the issues extend to many other occupations where the main hazards are management-driven stresses, not physical accidents. Let me give you a quick map of where I'm going today. First, I start with a short introduction just to set the problem clearly. Second, I step back and give some context. The psychological risk in finance and accounting work, how the statutory scheme treats psychiatric claims, and the pathway to common law. Third, I move to summary and critique of the current law, showing how the framework operates in practice and where it falls short. And finally, I finish with suggested reforms and a conclusion, focusing on what can be done to restore fairness, sustainability, and integrity in the system. Psychiatric injury is one of the most disputed areas in the Queensland Workers' Compensation Scheme. The pathway to negligence is narrow because workers must first clear multiple statutory hurdles. Section 32 subsection 5 of the Workers' Compensation and Rehabilitation Act is central here. It excludes psychiatric claims said to come from reasonable management action. That clause has been used to exclude between 91 to 97% of the rejected claims over the last decade. These barriers don't exist in the same way for physical injuries, and that creates an uneven playing field. Finance and accounting workers are especially exposed because their claims are routinely characterized as management related. So my research is about more than statistics. It examines the doctrinal, policy, and constitutional issues with Section 32 subsection 5. This research has three main parts. First, I look at how the scheme is structured and applied within the statutory no-fault system. Second, I examine how Section 32 subsection 5 actually operates in practice, not just in theory. And third, I analyze the pathway to common law negligence under Part 8 of the Workers' Compensation and Rehabilitation Act, especially for finance workers. From that scope, three questions drive the analysis. How does the framework construct liability for psychiatric injury? Does the scheme in reality balance fairness, sustainability, and affordability as promised in Section 5, subsection 1a? And what reforms are needed to restore both doctrinal and constitutional integrity? In finance and accounting, risks aren't usually machines or accidents. They are structural pressures built into the work itself. There are the obvious ones: year-end and quarter-end reporting deadlines, merger and acquisition projects, and chronic under-resourcing of teams. Those pressures create environments where psychological strain is almost inevitable. If workloads are poorly managed, the impact can be severe. Mismanagement isn't just inconvenient, it can damage psychological well-being. Employees need to recognize signs of distress and respond because the law expects it. In fact, unmanaged risks can amount to breaches of Section 305 subsection B of the Workers' Compensation and Rehabilitation Act. That's the duty to take reasonable precautions against foreseeable harm, including psychiatric injury. In financial roles, the risks aren't only workload pressures. There are moral injury risks too. Workers may feel pressured to misreport information or fear reprisal if they raise concerns. On top of that, management action under Section 32 subsection 5 of the Workers' Compensation Act plays a crucial role. Performance management has to be carried out reasonably and fairly, and when those lines are crossed, the employer's liability for psychiatric injury increases. Before looking at the exclusions, we need to define who counts as a worker and when they are covered. Under Section 11 of the Workers' Compensation and Rehabilitation Act, a worker is someone employed under a contract and treated as a pay-as-you-go employee for tax purposes. Coverage is then set by Section 33 to 36. Injuries must arise in the course of employment, which includes being at the workplace or engaged in activities connected to the employer's business. Section 32 of the Workers' Compensation and Rehabilitation Act defines psychiatric injury. It must arise out of employment, and work must be a significant contributing factor. But subsection 5 carves out major exclusions. Claims fail if the harm is said to result from reasonable management action taken reasonably, if it is based only on workers' perception of the action, also if it arises from the conduct of the regulator or insurer. These exclusions form the sharpest barrier. The impact of Section 32 subsection 5 is clear. Between 91 and 97% of excluded psychiatric claims are rejected under this provision. The burden falls squarely on the worker to prove injury. When management action is assessed, it is judged on how it was carried out. Perception alone doesn't decide the case. The law says actions must be reasonable, not perfect. And if actions overlap, they are assessed together in the overall context. Some psychiatric claims do get accepted, usually in narrow circumstances, for example, operational trauma or systematic hazards, as the case Elwood, or when management processes are unreasonable, like ambush meeting or intimidating conduct, as the case Maher. But the pathway is rigid. The insurer decides first. If rejected, review goes to the regulator. Workers have 3 months to appeal the decisions of the insurer to the regulator, and if it's still not satisfied, appeal could be done to the Queensland Industrial Relations commissions, which here the case de novo means fresh hearing. And finally, the appeal from the decision of the Queensland Industrial Relations Commission can be done to the Industrial Court of Queensland. However, it is limited to errors of law or jurisdiction. Negligence claims can't begin until the Chapter 5 statutory process is completed. If the degree of the permanent impairment is below 20%, workers must either take a lump sum or pursue damages. At 20% or more, they are entitled to damages. But if the claim is denied, no notice of assessment is issued. That means no negligence claim can start unless the decision is overturned on review or appeal, a process that can take years. At common law, employers owe a duty to take reasonable steps to prevent foreseeable psychiatric harm. They may generally assume workers have normal resilience, as the case Kohler and Serbas, but persistent signs of distress or workplace pressure make the risk foreseeable, as confirmed in case Akers and Cairns Regional Council. And where management conduct involves humiliation or demotion, as the case Gaines and Pro Music, liability for psychiatric harm become clear. In Kohler and Serbas, the High Court set boundaries around an employer's duty of care. Absent observable signs, complaints, medical certificates, or behavioral changes, employers are not expected to predict psychiatric harm. Ordinary workplace stress is not enough to establish duty. Without warning signs or inherently traumatic work, psychiatric injury is not foreseeable. Employees are encouraged to raise concerns early, otherwise employers may assume normal resilience. Section 305 subsection B of the Workers' Compensation and Rehabilitation Act sets out explicit breach factors. First, probability. Was psychiatric harm reasonably likely if no steps were taken, such as ignoring repeated complaints? Second, seriousness. Could the harm be severe or long-lasting? Third, burden of precautions were simple, low-cost steps available like workload adjustment or private meetings. Finally, social utility. Does the activity justify the risks, or should it be managed more safely? Negligence law doesn't demand perfection or absolute safety. It requires only reasonable precautions, judged against the probability and seriousness of harm. Very low probability risks may not need precautions, and reasonable care doesn't require eliminating every possible risk. The law balances safety with practicality, avoiding unreasonable burdens for rare risks. But if the probability is low, yet the potential injury catastrophic, then greater precautions are required. Causation under Section 305 subsection D has two steps. First, factual causation. The worker must prove the breach was a necessary condition of the psychiatric injury. Second, scope of liability. The court decides if it is appropriate to extend liability, essentially a remoteness or policy test. Workplace conditions must significantly contribute, as in the case ACUS, and the eggshell skull rule applies, so workers can recover even with pre-existing vulnerabilities. Employees also have defenses to psychiatric injury claims. Contributory negligence under Section 305 subsection F to 305 subsection H can reduce damages, though courts apply it cautiously. Voluntary assumption of risk is technically available but rarely succeeds. Proportionate liability allows fault to be spread across multiple defendants, and under illegality rule extra causa, claims may be barred if the psychiatric harm arises in the course of unlawful activity. Now we turn into the critique of current law. Section 5 of the Workers' Compensation and Rehabilitation Act sets out both fairness and cost control objectives. It promises fair and appropriate benefits for workers and their families, but also insists that employer costs remain reasonable and that the scheme not burden industry. That balance is inherently contradictory. On one side of the scale sit employers, the state, and the insurer. On the other, the injured worker. It is not hard to see which side is heavier. Continuing with critique of current law, this chart shows why cost pressures dominate. Since 2017-2018, total scheme payment for psychiatric claims have risen fourfold, from around 59 million to more than 230 million. For a self-funded insurer like WorkCover, these numbers are not seen as evidence of unmet psychological risk, but as a financial threat to the fund. And when cost control sits opposite fairness in Section 5, it's clear which side of the scale tips heavier. WorkCover's own 2024-28 corporate plan makes the priority clear. It describes mental injuries as a growing financial challenge and frames them in terms of sustainability and cost. The language is about managing frequency, cost, and poorer outcomes. It is about protecting the fund, moderning businesses, and influencing stakeholders. When mental injury is written into strategy as a financial risk, it shows how cost control objectives in Section 5 dominate over fairness to injured workers. This chart shows the breakdown of damages in successful psychiatric claims. About half is future economic loss, another quarter is past loss, and roughly 13% is rehabilitation. That tells us something important. By the time workers succeed, their careers are effectively over. For WorkCover, This creates a clear incentive to block claims early. Delays, filtering, and high rejection rates reduce the largest cost component, which is future economic loss, before it ever reaches court. This chart shows how cost containment happens at the very first filter, which is the insurer decision. Rejection rate for psychiatric claims have stayed virtually unchanged between 50 and 60% every year, despite different workers, workplaces, and circumstances. That consistency tells its own story. Half of all claims are stopped at the gate before any review or merit hearing. For insurers, rejection costs nothing. Acceptance triggers wages, treatment, and exposure to damages. So Section 32 subsection 5 makes rejection the rational cost-saving choice. The second filter is the regulator. When workers challenge insurer rejections, around 60% of the insurer decisions get confirmed year after year. This consistency raises the same questions as before. Are these genuine merit reviews, or is the regulator aligned with budget-driven cost control? And remember, the regulator is not independent. It writes policy, enforces compliance, and defends its own decisions in court. That structural overlap makes it less a check on insurers and more on extension of the first filter. The third filter is at appeal stage. Fewer than 1 in 5 psychiatric appeals now reach a decision on the merits. Around 80% are withdrawn each year, and the proportion reaching court keeps falling. This raises a serious question. Are workers truly being heard, or is attrition the real design? By this point, most claims vanish, not because they lack merit, but because the process itself exhausts them. At the judicial stage, the pattern is clear. Between two-thirds and 85% of psychiatric appeals are either dismissed or struck out by the courts. But by the time a claim gets this far, the system has already done its work. If the target was to hold acceptance to around 50%, that goal is already met. What looks like a courtroom outcome is really the end point of filtering that began at the insurer stage. At this point, the constitutional issues come into focus. The Cable case tells us that institutional integrity belongs to the courts. Yet, here, Section 32, subsection 5 exclusions are applied by insurers and the regulator through a multi-stage administrative process. The Kerr case warns that jurisdictional error must remain open to judicial scrutiny, but this scheme insulates much of it. And the KO case reminds us that natural justice requires a genuine hearing, yet every few matters ever reach a court, so procedural fairness is denied in practice. Now we turn into suggested reforms and conclusion. The diagnosis is clear. Section 32, subsection 5 drives consistently high rejection rates and heavy attrition, blocking workers from negligence claims, even when where fault is apparent. So reform is essential. The focus must be on three things: resetting Section 32, subsection 5, so the burden shifts back to the employers and insurers, removing the statutory precondition that blocks access to the negligence, ensuring independent review and genuine procedural fairness. Only then can the scheme restore balance between cost control and justice. One key reform, as mentioned, is to reset the burden in Section 32, subsection 5. Right now, the worker must disprove that management action was reasonable. The reform would shift that evidential onus to the employer or insurer, requiring them to prove their action and its delivery were reasonable. This is not radical. It already exists in New South Wales under Section 11A of the Workers' Compensation Act 1987, and in Hague case, the courts confirmed that the onus rests on the employer. In the interest of justice, it is the employer, insurer, and regulator who hold the records and control the management action. That should prove reasonableness, not unwell self-represented workers. Unlike common law, Section 32, subsection 5 creates an extra statutory exclusion on top of the existing adopted shared calculus and causation tests from the common law negligence principle. So it should justify the reversal of the burden. The second reform is to remove the statutory claim precondition for negligence actions. Workers should not be forced to obtain acceptance of a no-fault claim before pursuing common law negligence where fault is obvious. The floodgates argument is baseless. No such restrictions apply in road accident or public liability claims, and the courts have not been overwhelmed. In reality, the rule protects insurers, the state, and employer premiums, not justice for workers. The third reform is to establish the structural independence of the regulator. At present, it wears too many hats: policy making, enforcement, and reviewing its own decisions, creating conflicts of interest and undermining fairness. The New South Wales SERA model shows a better path, operating at arm's length with separated functions and representative parity. Queensland needs the same: a regulator that enforces the law, not one that defends insurers and blocks access to justice. The final point is not a reform but a caution. The pattern of withdrawals, delays, and cost orders exposes constitutional fragility. When 3 out of 4 claims are withdrawn before judgment, that is not reformable detail. It is a structural flaw that denies fairness and risks constitutional validity. To conclude, the reforms are straightforward. First, remove the statutory claim precondition. Section 32, subsection 5 protects budget, not justice. Second, shift the burden to employers and insurers to prove the reasonableness. Third, make the regulator enforce the act, not defend denials or protect premiums. And fourth, initiate judicial review of withdrawals and test the act's compliance with Chapter 3 of the Constitution. Thank you for your time and attention. I appreciate the opportunity to present today.